Hello, my true crime lovelies. How are you? I hope you are well. If you are not well, I hope you are working toward being better. I've missed you guys. I'm back. I've got the finale of the Sarah Boone family trial. Oh my God. It's an hour and a half of raw footage. So members have already seen it without commentary. And I have to tell you, just the idea of sitting here for 2 hours in a chair at 8 months pregnant was brutal. But I'm here. We're going to get it done. I'm all in. And you'll actually, in this video, be able to see when I enter the courtroom. But oh my goodness, the level of just editing it. So I want to thank Human Tooth, who has done an edit of the whole video together, right? She provided the footage. She attended via WebEx. I have gone back in and re-edited it so I can fit in one of the boxes and do my commentary. I know we got a lot of feedback that it was too fast last time. You always have the opportunity on your end to slow it down. But I will not have as many cuts because I'm not sure, maybe you meant the cuts were too fast. Anyway, the amount of brain cells I have lost on Sarah Boone. I do want to say, oh, I'm in reverse, that 9 times the judge told her why we were there, why they were there. And so I just want to what what the judge is going to decide is whether to eliminate or reduce alimony that Brian has to pay to Sarah. She's saying they already agreed to child support, although it kind of wavers back and forth. But she has agreed he doesn't owe her any child support. What was on the table was she wants the ability to designate how the funds are spent. The other issue is the parenting plan. So she agreed to the relocation, which they've already been there since 2023. I feel like it's kind of moot, but whatever. Sarah will argue with the stop sign, as my great Graham would say. And there's a parenting plan that's a part of that. She didn't want to agree to that. She never put in an actual parenting plan. She put in a 33-page rant that had those things likened unto a parenting plan, but was not an official parenting plan. So they're arguing also over the parenting plan and then attorney's fees because Brian is alleging had Sarah just been agreeable, this one would have been dragged out for years and years, right? Because he filed for his modification in 2022 for the child support and the alimony. And then in 23, he filed and got a temporary relocation in 23. We're now in 25 and she still hadn't agreed to anything. So he's alleging because she took so long, he's incurred $14,000 in attorney's fees, right? So there's where we are. This case law says Brian is responsible for paying alimony from 2020 to 2022, which is the time that Sarah was incarcerated, but he had not filed a motion to reduce or eliminate. However, child support retroactive till the day that she could no longer share in time sharing, and in Florida they refer to it as time sharing. Most other states refer to it as custody. But obviously she was arrested February 25th, 2020, and so she couldn't participate in time sharing, right? They don't, thank God, let you have your children in jail and or prison for overnights. So that's kind of the groundwork in case you haven't seen the other two videos, or I know it's been a while since I've posted those in case you've forgotten. So, all right, let's get into it. I'm going to thank the members and then we're going to, by playing the intro, because it has all the members in there, and then we'll hop right into it and just get your popcorn, get your Diet Coke, your lemonade. I've got lemonade today. Whatever it is, because you're going to lose a few brain cells, right? So, all right, I'll see you on the other side. righty. Here we go. And I need to update that members list. We're at over 600 members. So I want to really, really thank all the new members. I appreciate you. And we're at like 23,000 subscribers, which is like bonkers to me. Mainly from the Charlie Adelson video, I think. I don't know. Everybody's been watching the Charlie Adelson eating Wendy's video. And they even went back to Donna coming to Tallahassee from Miami video. So I appreciate all of you. I'm amazed that anybody wants to listen to what I have to say, but thank you for being here for my 2 cents. Okay, without further ado, let's look at Judge Jackson's face. So we're coming back from a break. Like, they took a break in the court. So the last thing the judge was like, bailiff, do you need a break? We were all like, man, we all need a break. Okay, let's go.
I'm here, Your Honor.
Okay. All right. I don't know if I may have accidentally hit mute again. We just located your exhibit that was entered into evidence as Exhibit 1. The clerk now has that. Before we took a break, Petitioner's counsel indicated he did not have any additional questions for Mr. Boone. So now I turn back to Petitioner's side and ask, do you have any additional witnesses or evidence you would like the court to consider?
I would call Ms. Boone very briefly.
All right, Mrs. Boone, counsel has some questions for you. And once he is done, what I'll probably do is I'll ask you, do you have anything that you want the court to know right away based on the questions that he has? And then we'll get and see if he has any additional witnesses and evidence. And then I'll turn it over to you for your presentation, okay?
Yes, Your Honor.
All right, you may.
So in case that wasn't clear, Brian's side is going to finish out their case in chief. Then it's all Sarah.
Thank you, Your Honor. Ms. Boone, you filed the financial affidavit in this case on May 30th, 2025. Is that correct?
One moment, please, and I'll pull it. Okay. Go ahead with your question while I'm looking for it.
Well, I want you to locate it first because I want to ask specific questions about specific pages. So I'll wait for you to locate it. Did you receive the exhibits that we sent you? Because it also would be in that packet as well.
I have it located.
Okay. And that financial affidavit that you've located, that has a stamp on the top of it that says that it was filed at 1:08 p.m. on May 30th, 2025. Is that correct?
Yes.
Okay. At this time, Your Honor, I'd like to submit what has been previously marked as Petitioner's Exhibit E, which is the respondent's financial affidavit filed on May 30th, 2025, into evidence.
Any objections to the court considering your financial affidavit that was filed May 30th, 2025, Ms. Boone?
No, Your Honor.
All right, hearing no objection, I'll receive into evidence what was pre-marked as E as petitioner's number 3.
Okay, ma'am, I just wanted to ask you a few questions about your affidavit. And I'm going to just laser focus right in on your expenses section, which starts on your page 6 of the document, and for the court's following of my exhibit, bait stamp page 46. Let me know when you're there, Ms. Boone.
I'm there.
Okay. So this section here is going through what you estimate to be your expenses. The first question I had for you is, have these expenses changed dramatically since you started your incarceration in February of 2020?
They haven't changed because they've never started. It's just an estimate from going off of the canteen list.
Okay.
So they haven't changed because they've never started. So they're not real expenses. These are pipe dreams, right? She has filled this out so that she can demonstrate why she needs $1,000 in alimony. She's submitted no case law that supports that once you're imprisoned, you get alimony, because there isn't any. Like, the state of Florida is taking care of you, ma'am. Yeah, so she's just made up some numbers.
So from February of 2020 until today, you have not actually incurred any of these expenses that you've listed on your financial affidavit. Is that correct?
You're asking me from when I was at Orange County
Yes.
to the present day?
Yeah, I asked you the question about these expenses, and you said you mentioned something that you haven't actually incurred these expenses yet. So that's what I asked a follow-up question to that of, are you telling me that since you started your incarceration in Orange County in February of 2020 until today, have you actually not incurred any of these expenses that you've listed here on your financial affidavit?
What do you mean by incurred, please?
I mean, I've always been a straight-A student. I am an outstanding mother to my son. I excel at everything.
Have you had to pay them?
Have I had to pay for food? Yes, I have.
Okay. So, has it stayed though? My first question to you though, in which you answered it in a different way, so I want to answer it again. Ask you again is, for example, you have here on your financial affidavit that you filed in 2025 that your food expense is $250. My question is, has that number gone dramatically up or gone dramatically down, or has it stayed relatively the same since you started your incarceration in February of 2020?
I don't know or remember in regard to my incarceration 5 years ago, but I know for the current time, this is just an estimate because the prices fluctuate. So as of right now, it's about the same.
Okay. Now, does the facility that you're incarcerated in, does it provide you meals for free?
It does.
Okay. Does it provide you breakfast, lunch, and dinner for free?
Yes.
Does it provide you any other meal times other than those 3 times for free? Snack times or anything like that?
No.
Okay. Does it provide you things to drink for free?
Water, yes.
Okay. So when you indicate here that you have a estimated food expense as of May of 2025 of $250, what is that for?
That is for my low blood sugar, which the petitioner is aware that I have ongoing. I need to maintain my blood sugar. My grandfather died of diabetes, and I have to maintain that with snacks and in between meals. Some of the meals are...
Now, I hate to stereotype anybody, particularly a fellow sister, but I would like to imagine that Judge Jackson has some diabetics in her family. I could be wrong. Like I said, I hate to stereotype. Even if she doesn't, I think we all know snacks are not what you use to manage your blood sugar. I don't know what her granddaddy had, but I'm pretty sure honey buns was not what the doctor prescribed. But she's going to call them medical snacks, medical later, so just buckle up.
Of course, unappetizing, and my stomach is not able to handle.
Let me go back.
That is for my low blood sugar, which the petitioner is aware that I have ongoing. I need to maintain my blood sugar. My grandfather died of diabetes, and I have to maintain that with snacks and in between meals. Some of the meals are, of course, unappetizing, and my stomach is not able to handle them properly, so I either do without or would fall back on something that I could order or purchase from Canteen.
How is that Brian's problem? Have you talked to the nurse, the doctor? Are they prescribing the Zuzus and Wham Whams? Is this self-diagnosed? My great grandma had diabetes. Is that something you can die from? Specifically, she, I think, died of old age, but she was diabetic. Now, she would take a glass of orange juice when her blood sugar was low, like for a quick boost. She did have some strokes when it got a little too low, but Snicky Snacks, Zuzus and Wham Whams, that was not on her list.
And are you actually incurring this expense in purchasing additional food above and beyond what the prison is offering you for free?
I have from contributions, yes, but on a regular basis, no.
Okay, explain to me these contributions. What are you talking about when you say from contributions?
Do tell.
I have a friend that will deposit money in my account on a rare instance when she has an extra or something spare.
Okay.
So I hope the Flying Monkeys are watching this. She's deduced your collective, what is it when you fly together? Flock. She's reduced your collective flock into one person who gives her money on a rare occasion. So that would have been Lana, who is now deceased, Christina, who's scraping by, sending her money, sending Sarah money, sending her trafficker / boyfriend money, Nicole, Peter, obviously her brother Philip, but she is gonna give him a shout out. So who else was giving her money? The LaFontaines have given her money. Chaplin has given her money. They've all been reduced to one friend who on occasion. So how did she get to the $250? That's what she would like to have? And if so, how is that Brian's problem? She wants to take money out of her son's household so that she can have Zuzus and Wham Whams. Does that sound just or fair to anybody? Let me know. I'm not being facetious. To me, it sounds selfish, but like, as a mom, I would give my child, if there was one piece of bread left, I would give it to my child before I would eat it. But I get everybody's not built like that.
Do you have any other contributors?
My brother, when he's able to.
Okay. So if I understand you correctly, this food expense is not for breakfast, lunch, or dinner. It is for supplemental food that you believe is appropriate due to your blood sugar. Is that accurate?
Yes, and also in regards to the meals not being able to be digested properly.
So everybody else in the prison can digest it properly, but you. So is this another medical issue? Maybe your liver and kidneys are like, girl, we've had enough? I need details.
Okay.
Primarily for medical reasons.
And then you have on here another charge of $100, or another expense of $100 for gifts for holidays. Is this for gifts for your son?
Yes, that's under child expenses.
And is this $100, are you asking that Mr. Boone pay you this so that you can give gifts to your son?
Would he be paying the alimony arrearages or any dollar amount? Yes, I would like to have that deducted from that dollar amount because I don't have income on a regular basis.
Okay. So you want your husband to give you alimony so that
My
you can...
ex-husband.
You're right, excuse me. You want your ex-husband to continue to
Ex, come on. He's your former husband. Get it right, Sarah.
give you alimony so that you can then turn around and purchase gifts for your son on your behalf, because you cannot purchase those gifts because you're incarcerated. Is that correct?
My alimony payments can be spent however I make or decide how to do so. And yes, I would like to include my son for gifts on holidays or just because I love him. Yes.
That's the entitlement. My alimony can be used however I want. No, ma'am. What we're trying to figure out is, what do you need the alimony for, right? Like, you've got it backwards. You put in the cart before the horse. The horse is the need for alimony. The cart is then you spend it on what the need was based on. You don't need to send your son gifts. You don't need to take money out of his household to redirect it to gifts that are probably inappropriate. See also fish soap from the text messages.
That would be a part of my disbursement of my alimony.
Do you think it's fair for Mr. Boone to give you money to purchase gifts for your son that you can't afford to purchase because you're in jail? You think that's fair
Because you've murdered your boyfriend.
to him?
Alimony,
Weird.
yes, that would be a part of my disbursement of my alimony.
Do you think it's fair for Mr. Boone to give you money to purchase gifts for your son that you can't afford to purchase because you're in jail? You think that's fair to him?
Alimony is court order, which
Okay.
is unfair that I have to not be paid what I could have been paid.
Okay. You also have on here that you have a $200
But we're here to determine if it will continue to be court ordered, and if so, at what amount. And she's not substantiating that. Like, gifts, girl, because you're in jail and can't have a job in prison? No, ma'am.
communication charge. Is that for the phone calls that we've been talking about?
That's for all of the communication opportunities that have not been taken advantage of by the petitioner. It's not just phone calls. It's video visits, it's videograms, it's cards, it's a multitudinous amount of technology.
Multitudinous amount of technology. So, video visits, maybe. Videograms. Is that like, what is that one? Not OnlyFans. Oh my God. What is that app where Cameo? Is it like Cameo? Like you just send him a little like, hey, I was thinking about you. Why should Brian have to pay for that? And I would say if we're doing video visits, then let's do those instead of in-person visits. Can I get an amen?
That is available to be utilized if decided to.
Every effort, every expense that's been occurred. Oh, I'm sorry. You want to finish your point?
No, I was just stating that it is located in my exhibit, so you all are aware of the opportunities
All right.
and the cost.
Okay. I want to be clear, though. Every expense related to you communicating with your son, since you've been incarcerated, Mr. Boone has paid for that. Is that correct?
It's my only form of ability
Ma'am,
right now.
answer
Yes.
the question. Has what the communications with the child been paid for by Mr. Boone since you've been incarcerated?
Yes.
Yes.
Okay.
Next question.
You have a $50 charge here for clothing.
Okay. Uh-oh. Did you guys see that? Hold on. I snuck in right there. Hold on.
Since you've been incarcerated, Mr. Boone has paid for that. Is that correct?
It's my only form of ability
Ma'am,
right now.
answer
Yes.
the question. Has what the communications with the child been paid for by Mr. Boone since you've been incarcerated?
Yes.
Okay.
Next question.
You have a $50
There.
charge here for clothing.
It was very quick. I'm in the pink. I've arrived. Okay.
Does your prison provide you with clothing?
Yes, the prison
Okay.
provides uniform.
Okay. And then you have $15 here for medical and dental. Does the prison offer you any medical services?
You have to have a lien against your account. To make a sick call, you have to pay for that. For dental, you have to pay for that. Regardless if you have an insurance plan or not, you still have a lien placed against your account.
Okay. And you are estimating that your cost for that is $15 a month on your financial affidavit. Is that correct?
Yes.
Okay. And then you have here other hygiene and writing items. Does the prison provide you with basic hygiene items?
No. The prison only supplies I believe, 1.5 ounce all-in-one shampoo and body wash, toothbrush, and toothpaste.
Okay. Those would be considered hygiene items, correct?
Yes.
Okay. And
So,
you
yes,
have here
they
a
provide them.
$50 charge for creditor Department of Corrections. Are you indicating that you owe the Department of Corrections money?
These are all estimates. And you need to please remember that I am new to DOC and don't understand, but I do know that weekly draws pulled from everyone's account every week. So depending on how much money you have in your account is how much they deduct from your account. This was just an estimate. I'm not even sure how they go by what they do, but this was what I was told to do from one of the classifications officers.
So classification officer is helping you fill out your financial affidavit. It's pay to play in Florida. Like it was $270 a day in jail. I don't remember what it is in prison. But again, why should Brian have to pay because you murdered your boyfriend?
And a lot of these, if you see at the bottom, it states estimates for all. The clothing is charged quarterly. It's not every month. And there's limited quantities, and also the prices fluctuate, which is why I included those as my exhibit so you all would understand the most current pricing.
Other than receiving contributions from third parties and receiving money from Mr. Boone, since you've been incarcerated, have you had to pay any money out of your own pocket to meet your day-to-day needs while you have been incarcerated?
Sir, I have no money.
I'm sorry, I didn't understand your answer. What did you say?
Sir, I have no money.
Okay. So the answer would be no, correct?
I have no way of doing so. No, I do not have any way of paying.
I have no further questions, ma'am.
Ms. Boone, I will give you an opportunity to talk about the financial affidavit in just a minute, but I'm going to ask counsel any additional witnesses.
No, Your Honor, I just have some reserve a little bit of time for closing argument.
All right, any additional evidence?
No, Your Honor, just some demonstrative aids that I'll be arguing in closing.
All right, Mrs. Boone, counsel has indicated that he has no additional witnesses or exhibits for this court to consider. I am now turning it over to you to present any evidence that you want this court to consider and any testimony you want this court to consider. And that includes any testimony or any explanation or additional testimony you want to provide to the court regarding your financial affidavit. Once you are done, counsel for petitioner will be able to ask you some cross-examination questions as well, okay?
Yes, Your Honor.
All right. And again, I'm going to say to you again, the topics we're here on today is the proposed parenting plan that was admitted into evidence as petitioner's exhibit number 1, that was pre-marked as G in the packet of materials that you received, as well as the request to have the alimony of $1,000 per month discontinued and the issue of child support of $100 per month discontinued, and the request for attorney fees. Those are the only issues the court is considering today. Those are the only issues that you will be permitted to provide evidence on at this time. Okay?
Forgive me, it's Exhibit D, the proposed amended parenting plan, the attorney fees, and what was the last?
Do you not
The
have a
request to
pencil?
discontinue alimony and the request to discontinue child support, which I think you said you agree that he should not be paying child support as of February of 2020.
Okay. So parenting plan, attorney fees, and alimony.
Correct.
Okay. So for the parenting plan, I would like please to put into evidence my number 2 and 3. I'm sorry. The parenting plan, the original one.
The judge is being extremely generous with this Little Miss Pro Se Boone. Normally, you would have to lay some sort of foundation in order to get evidence entered on the record, but I think the judge is like, let's just... Maybe she's made up her mind. I'm not going to speak for her, but it's like, okay. I think she already knows what she's going to do. So she's giving her this leeway.
My number 2.
All right, give me just a minute.
Were it signed by those parties?
Counsel, do you have any objection to what Ms. Boone had pre-marked as Exhibit 2, which is the parenting plan that was filed with the court back on May 9th of 2018, coming into evidence?
No, Your Honor.
All right, hearing no objection, I'll receive us into evidence what was pre-marked as Respondent's Exhibit number 2 as Respondent's Exhibit number 2.
So that was 7 years ago, right? She's harping on the one that is signed 7 years ago. I have a whole video on how she has violated that parenting plan, but in her mind, that's the one they should be going by. And so she's going to harp on why hasn't Brian been complying instead of focusing on why we were there that day of, ma'am, what would you propose the parenting plan be, right? And the judge is going to call her out because she wants to say what Brian hasn't done. But obviously, February 25th, 2020, she also was breaking the parenting plan. She couldn't do overnight. She couldn't do any time sharing because she was incarcerated.
All right, what was the second document?
The second document is the certificate of completion for the parenting and divorce class, number 3 and 4.
All right, for the record, I have here what Respondent marked as 3. It is a parenting class certificate that was filed back on April 24th of 2018, and which is pre-marked as 4, is the parenting plan certificate filed back on May 15th of 2018. Any objection to Exhibits 3 and 4?
No.
All right, I'll receive into evidence what was pre-marked as 3 as Respondent's Exhibit number 3, and what was pre-marked as 4 as Respondent's Exhibit number 4. What's next, Ms. Boone?
Am I allowed to explain those?
All right, I don't know that any explanation is necessary, but go ahead.
In regards to the parenting plan, first and foremost, I would like to state that one moment.
What does that have to do with the new parenting plan?
From my parenting, or from my pretrial statement, please, I would like to say that my incarceration has nothing to do with me as being a human being and a mother to my son.
Who said
I've
it
done
did?
everything I possibly can to be a part of his life, regardless. And with the active parenting plan, my former husband has excluded me from my son's life in every way, shape, and form and alienated me, which is not part of the active parenting plan. So since 2020 of my incarceration to the present date without any modifications, he has followed the parenting plan in regards to trying to encourage the relationship as discourage the relationship. The point of my certificates of completion are to show the different topics that were covered in the court-ordered class that he had the understanding that he was supposed to abide by in regards to acting appropriate towards the other parents in front of the child, which he has not done. And
Self-serving hearsay. This reminds me of, remember what those trifold boards we would have when you had to do a presentation, like elementary school, maybe early high school? Like, I feel like she should put them up there. Like, here's the parenting plan. Here's the certificate we signed. Here's the one Brian signed. Here's the one I signed. See what this is? And if you go to page 4, it says, do not, and he's been doing it. And then if you were like, ma'am, what does that have to do with the parenting plan that you are proposing the judge make an order about?
the burden of proof is on the opposing party to show unfitness, and I shouldn't have to prove my worthiness. And I've done everything I possibly can in regards to be a part of my son's life. And as you heard the petitioner himself say, he doesn't care. He does not answer my phone calls. He does not answer my tablet messages. He does not respond to my letters. He's not made any attempt to find out any contact information. He's not done anything in regards to have me be a part of.
So the parenting plan, or one of the marital documents, specifically states that it is the responsibility of the party that has changed their contact information to notify the other person, to keep them apprised, abreast, updated, whatever you want to call it. So it's not Brian's job to call the prison and figure out how to contact Sarah. It's Sarah's job to communicate to Brian, here are the ways that I can be contacted.
My son's life, and is now going from having me speak to my son on an almost regular basis down to one 30-minute phone call. I believe that is more detrimental to my son as opposed to helping him when.
So now she's going into disparaging Brian again. That is detrimental, but she gives no evidence, nor does she state what her preferred thing is, which is mind-boggling to me, because I feel like Brian's attorney went through all the things he wanted, explained why, and went on. He wasn't necessarily going on and on and on about what Sarah had done or not done. Now, he did mention, Brian said she wasn't good at decision making. She needs help. I don't know that that's disparaging. I feel like the reason she's in prison is because she's not good at decision making. She made a conscious decision to leave George in a suitcase and go upstairs and go to sleep. So is that disparaging or is that fact? But she's going to go on and on and on about things that Brian hasn't done, right? So it's, again, she's using, in her mind, the judge, the judiciary, as a way to control Brian in the same way that she used the police to control George. But Brian is like, girl, you a day late and a dollar short. I see you.
I have had my parental rights intact since day one of my incarceration, and have helped my son since the day he has been born.
Who's this?
He wanted to meet you. Actually, tell him what
you want to be when you grow up. Oh, please.
You want to be a cop? Great job, man. Stay out of trouble.
Thank you. See you tomorrow, Mom. I'll call you later.
Just as context, this is September of 2019, so her son is 8 years old. She is shit-faced drunk out here, and I just had to throw that in because she was like, I've been looking out for his best interest since day one. She has called the police to take her home. She's claiming George is there and she's fearful, but basically, I mean, who knew Winter Park Police are running a free Uber service?
But
That's your.
night termite, sir.
That's your.
I love you, baby head. Yes.
Oh, with your ex-husband?
Yes.
Okay. And this is where he lives?
Yes. Ooh, I can't see. You're going to my place?
Mm-hmm.
Shoot, I didn't realize my head was in the way. That's why we should look at the other monitor. Hold on. Too many options on StreamYard here. It's the tiniest I can make myself. Let's go up here. Okay. One more again.
You know, actually tell him what you want to be when you grow up. Oh, please.
You want to be a cop? Great job, man. Stay out of trouble.
Thank you. See you tomorrow, Mom. I'll call you later. Okay. But
That's your.
night termite, sir.
That's your.
I love you, baby head. Yes.
Oh, with your ex-husband?
Yes.
Okay. And this is where he lives?
Yes. Ooh, I can't see. You're going to my place?
Mm-hmm.
123 Foxtrot, Unit Check.
I think she's barefoot.
Told the employees,
It's right down the street.
Yeah.
I think it's going to the hospital. If you want, cancel.
You want? Are you going to park or just pull?
121, no, go ahead.
Well, I'm parking. We're all getting out. Where?
Right, blinking right in front of the office. They get to fix it.
That one right there?
I'm on out.
Yeah, I gotta let you out.
23 Echo 122. 25 Delta, Unit Check.
Thank you.
Mm-hmm.
It's always going to act surprised.
I'm sorry, I couldn't understand what you said.
What's his name?
George,
Okay. Does he have a car?
I'm sorry?
Does he have a car?
No. That's my car right there. He does have my keys, though.
Mm-hmm. You have a key? Well.
I'll see if he's even here, guys.
You have
That's
both
not
of these?
even her unit.
Oh, so then, okay.
She's like letting them flash the light, and that's not her unit. Like this is where the stairs are. Oh no, actually stairs are on this side. It's still not her unit.
Just, I can't get out of my house.
Well, you told me you're already getting kicked out.
No, I can't.
Is there a back door or a sliding door in it?
Yes. You may...
Nope, you're good.
If you go 10-12, just let us know.
Yep.
I said you already bailed.
What's your plan if you did?
I'm gonna want to call the police.
How are you gonna get inside?
My ex-husband actually has a spare key. Everyone's open?
121 Alpha.
A little bit.
Number 2112.
What about that?
Cancel. Air 29, check.
2112. 124 Delta, 124 Charlie, you just
Hello.
Maybe that is hers. Maybe that is the son's, the spare bedroom. I think I'm thinking, no, it's upstairs, right? But the stairs are on the other side because the neighbors who heard the suitcase going down are on the other side, lower unit.
2112.
Locked on the back.
No, so he locked the back too.
Yeah, the back's locked.
Hey, well, you want to call your ex-husband? You got a phone?
It's about the guy.
Okay.
There's a charger.
That's not to say that he's not in the house.
Near the elevators on the second floor, he's gonna leave.
Excuse me?
That's not to say that he's not in there, just because the doors are locked.
She's always, purple shirt.
I don't understand what you're trying to say. Do you think he's inside?
Yes.
Okay, well, we need a key so we can get inside and see if he's inside. That's what I'm getting at.
And if your phone's gonna die, there's a charger in back on the back side of the porch.
Oh, yeah.
Did you see how she went all Dr. Jekyll? Not inside. Took a beat. Excuse me.
Hey, if he's in the house, he's not coming to the door, but you have my spare key. I can't get in. If you could, there's no other way of me getting in the house. Unfortunately, can you please bring me my spare key? Yes, please.
She would have to call a locksmith if she was my ex.
The front door and back door. I have no way of getting in. Thanks, bye.
121 after you just walking to check.
Where does he live at, ma'am?
I'm sorry?
Is that you said that's your ex?
That's my husband.
He lives just right down the road.
Okay, thank you.
121
He'll be here in like
21 Charlie,
2 minutes.
Charlie
Perfect,
29.
thank you so much.
No, thank you.
Is your,
Now, why didn't she get the spare keys while she was there? So Brian is going to come out. Again, the son is 8. In most states, you can't leave a child alone until they're 13, right? So now Brian's got to get out of the house with the son. It says 1:14. Now that could be Greenwich time, but either way, it's late. But we're just gonna go with 1:14 in the morning over here, right? This is her caring about her son since the day he was born.
is your, who you think is your ex-boyfriend, is that correct?
This is my place.
Yes, ma'am.
Okay. It's a simple question. Your boyfriend or
It's not her place. George is on the lease. We've gone over that a million times.
ex-boyfriend?
I don't know what to call him.
Hey, but it's one or the other. That's a pretty easy one.
Yes.
Okay. Does
For
he not
3
have any
years.
weapons?
No.
Okay.
He was arrested last week for bad TV.
You guys actually want to take a picture of my ear? Look at that.
Arrested last week for something he was.
I saw he was arrested before. Was that on you also, like a month ago?
It was last week.
Here. Look.
This cop is so over her.
Correction, 120 Bravo, 120 Charlie.
That's why I called you out. And again, I was sleeping.
2115.
He hates it when I sleep.
How much has he had to drink tonight?
Only God knows.
How much have you had to drink tonight?
2 drinks. And that was what, 4 hours ago?
So what's the layout of the house? Is it both floors?
Yes.
Is this part of your, or is
Yes.
that, sorry, so it's these 2 windows right here?
Yes.
So she
What
said
kind of vehicle
no,
does he drive?
right?
I guess just stay up here. I'm gonna go around there.
When he said, so is this part of it? She says no. So why does she let him flash that light in there? I haven't edited this body cam footage into its own video, but it's on my list.
I saw he was arrested before. Was that on you also, like a month ago?
It was last week.
Here. Look.
Correction, 120 Bravo, 120 Charlie.
That's why I called you out. And again, I was sleeping.
2115.
He hates it when I sleep.
How much has he had to drink tonight?
Okay, I'll stop stopping it. But she says he hates it when I sleep, which is even more ridiculous that the night she murdered him, she went upstairs to go to sleep, thinking he could get out. If he hates it when you sleep, that seems like a very bad decision to go upstairs and go to sleep after you've hit him with the bat, after you've put him in a suitcase, and you believe he can get out.
Only God knows.
How much have you had to drink tonight?
2 drinks. And that was, what, 4 hours ago?
Mm-hmm.
So what's the layout of the house? Is it both floors?
Yes.
Is this part of your, or
Yes.
that, sorry, so it's these 2 windows right here?
Yes.
What kind of vehicle does he drive?
Well, you guys just stay up here. I'm gonna go around back.
But I don't
So here, the downstairs is where the younger boys, the college students, sleep. And here's the patio that she extended for the dogs.
That's him?
Y'all can have to sit. Y'all can open the door.
Oh, yeah, you're gonna stay outside so we can make sure nobody is inside.
I'll give it back. Thank you so much.
He's hanging out here.
Ma'am, I'm not going in there.
It says his name's George.
There's no weapon.
Okay.
That's for me. That's for me.
That's
I know, but.
it's not that.
124 Charlie. I'm just telling them.
So I edited out because they say her son's name, but Brian is talking about there's a bat in there when she's saying there's no weapons. And then so she says that's the son's, and he's like, I know, but I'm just telling them because we know the bat can be used as a weapon. Sarah knows because she did in part of her unaliving of George.
That's for me. That's for me.
That's
I know, but.
it's not that.
124 Charlie. I'm just telling them.
Thanks, sir.
You're welcome.
Can we get minimum traffic for village? Are they making announcements? Yep.
You guys don't have to do that.
Man, we have a way to do things.
Okay.
Just let's
Thank
do our
you.
thing, okay?
And I don't believe that they should be terminated or a 30-minute phone call should be viable.
So that's already moot because he said you can have an hour at a time back to back on the weekend. But it's going to be the one, you know what I mean? It's not going to be every day. So why is she still talking about this?
Because no alternative exists. My parental rights should not be taken away. That could just be a last resort, and I don't know why he's doing it, and I am used to him saying he doesn't care. And I believe that my rights should be preserved, and I have all of my case laws stating such. So I don't know when I'm supposed to state that, or if this is my opportunity. I don't know what I'm supposed to do. The minor child is very aware of these ongoing hindrances and speaks about to the respondent and his desire to see her in person, which she also has been asking petitioner about almost on a daily basis.
So that's a violation of their current parenting plan. The child should not be involved in those conversations. She's dragging him into those conversations, right? Because he wouldn't otherwise know that she can now have visits while she's at Lowell Annex, because for the prior 4 years, she hasn't been able to have in-person visits, only video visits. And it wasn't video visits on the tablet. It was like kind of like a teleconference. You guys know.
The minor child apologizes to the respondent regularly that the petitioner does not do and prolongs their overdue time together in person. The multiple
Yeah, so why would the son be apologizing to Sarah for the dad's actions? And why would Sarah allow it? Do you know what I mean? She should nip that in the bud. Babe, this is between me and your dad. We'll get it sorted out. No need to apologize. Don't worry about it. Mommy's working on it.
children's rights he has violated in regard to developing an independent and meaningful relationship with each parent because of the petitioner. He is present during the parents' personal battles while I'm trying to speak to him on the phone. To speak ill will, he has called me murderer and killerer in front of my son, which is another reason why I wanted to have a guardian ad litem, which has been denied, I believe.
Killerer. What is that? What is a killerer? You are a convicted murderer, ma'am. You are convicted of second-degree murder. You are doing life in prison without parole in Florida for committing second-degree murder. You are a murderer. I don't know what a killerer is. Chat?
3 times. It doesn't include me in any way, shape, or form in regards to anything that has to do with my son's life. I know a lot about my son. I know what his favorite color is. I don't believe that the petitioner even knows that much. The name of his girlfriend, the things they're going through. I am part of his daily life.
I bet my mom doesn't know what my favorite color is. She might. I know what my sister's is, but I don't think I know what my daughter's is. But are we in high school? Junior high? Isn't that when you ask those sorts of things? Like, what's your favorite color? And then she's like, I don't think petitioner knows. So what? He's raising him. He's taking care of him. Who gives a flying flip about his favorite color? As a determination of, like, your goodness, your worthiness as a parent.
For him to take that away from me is just out of bitterness and spite. I want to be a part of my son's life. And people forget that I have a pending appeal.
For everything you've done to me.
So, to prove my innocence, which is what I've been doing since day one, the reason why I was incarcerated in Orange County for over 5 years, or at least 5 years, was because I continued to fight for my case.
If you've been fighting since day one, and I'm assuming you mean February 23rd or 25th, 2025, it's not going well, ma'am. So I don't know what you're worried about people forgetting about your pending appeal. Meanwhile, you just got a new appellate attorney. You still don't have a brief submitted. And the 6th District Court of Appeals has not approved your former attorney's request for an extension, at least not as of 5/31 on September 8th.
I know that the petitioner understands the reasons why it's been enclosed 30% time period because of the danger and safety. There's a lot of things that I was trying to protect my son from. I'm not that parent because I was trying to make sure he was safe and in a safe place.
You guys just saw the body cam footage. Did it look like she was trying to make sure he was safe and in a safe place out at night, 1 o'clock in the morning? Could be drunk drivers on the road. You've got his dad bringing him out to get your keys because you can't get your household in order, ma'am. Really? But what does that have to do with the parenting plan you want going forward, the attorney's fees that Brian has incurred because of your difficulty, or whether alimony should continue. I'm listening.
The time sharing, it's, of course, it makes no sense to have the realization one is not what we're talking about now. I do not feel that it is right for me to have a 30-minute phone call with my son.
You already said that.
When I'm trying to do everything that I can to be in his life in every way, shape, and form that I possibly can, from having people in Australia purchase him a record. Anything that I can possibly do to go out of my way to do, I've been.
Was that you, Nicole? You purchased that record for him? You think that's helping him build a relationship with his mom? How so? Let us know. We know you're watching, girl.
Doing for him. So he remembers and knows that I am in his life and I am his mother and I am doing everything I possibly can to stay that way regardless of the petitioner and his counsel's attempts to deter me from being part of that. I try to communicate with the petitioner in regards to my son. I've been continuously excluded. There is no communication. I don't know what else it is that I can possibly do that I haven't tried to already. And a lot of these too, I would like to remind everyone, is these could have been solidified where they have had the meeting of attorneys and unrepresented parties meeting. A lot of this could have been had and resolved and narrowed if we were to have that meeting in regards to all of this. Nonetheless,
clearly it wouldn't have been resolved. You would have gone around and around in circles like you're doing right now. You're like negating your own point.
If the petitioner would have answered a phone call or a comment message, it's not fair to me that just because I'm here, it doesn't justify how I've been treated and excluded with it. I would like to continue to have the regular phone calls and interaction with my son, which I have been doing, and all of a sudden now is being tried to be taken away from me out of spite as opposed to my son and his growth and him moving properly and appropriately and lovingly forward with his mother. And
out of spite for what? Why would Brian be spiteful of you? It is self-serving hearsay. All right, we've been at it for a little over an hour. I've got to go get Sugar Bear from preschool. And I'll be back. But I will say, this is your warning. If little people in the background bother you, now's the time to click out, because it's important to take accountability for yourself and the things you can control, right? And let go of the rest. Let's take a break, and it'll be a minute for you and who knows how long for me. I'll see you shortly. We're back. I've got ginger ale now, some bubbles, finished off my lemonade. Little guy is home. It's freezing. Well, he runs hot. I run cold, so I put on the cardigan. And I think the AC is set to 73 and I'm freezing. So it may be a pregnancy thing. But let's get back in, shall we? Let me know what you're sipping on, where you're coming in from. What's good in the neighborhood? Here we go.
I would very much like, please, after 9 months of asking for my son to please come see me, which is only 50 minutes away. a tablet message.
We'll go
It's
back.
not fair to me that just because I'm here, it doesn't justify how I've been treated and excluded with it. I would like to continue to have the regular phone calls and interaction with my son, which I have been doing, and all of a sudden now is being tried to be taken away from me out of sight, as opposed to my son and his growth and him moving properly and appropriately and lovingly forward with his mother. And I would very much like.
So I disagree. I don't think it's out of spite. I don't think Brian has a spiteful bone in his body. I think he's been doing what's best for the son. I think even in his parenting plan is overly generous, offering to go 12 times a year, estimated at about once a month, is very generous. I think he's setting boundaries, and I think it's freaking out our little cluster B inmate. Let me know your thoughts. Do you think he's being spiteful? I know he said he doesn't care and all that, but he doesn't have to care. Do you know what I mean? Like, why would he care what your job is, what your hours are? Right now, you're a leech, ma'am.
Please, after 9 months of asking for my son to please come see me, which is only 50 minutes away, which I think will change both of our lives with finally being able to see. I don't know if you can hear me, but there's incredible feedback. Static.
All right, we can hear you. You can continue.
I would like from the parenting plan, my resolutions, please. If I need to, I don't know what I'm supposed to do if I say it again. If that's on record from previous, but the daily telephone calls, personal space for him to grow up as the teenager that he is. He's going to be a legal adult in 3 years, which is why I'm unclear on why he's fighting for this. So the petitioner, nonetheless, I've not been included in anything major or included in an ending period since day one. So I don't understand. But I'd like to have, please, tablet messages, all of the features, everything that I can possibly have still, please, to be in my son's life. This is another reason why, too, that I was trying and adamant to have a guardian ad litem appointed. And I believe that I would like to suggest that some kind of co-parenting course or counseling in regards to how to treat the other parent, which he has already taken, but back in 2018 upon our original divorce. So he can be reminded, please, on how to treat the other parent.
So she's asking that Brian retake the parenting class on how to treat the other parent. You guys help me out, because like I told you, I've lost brain cells over Sarah Boone. Where does this fall under? Does that fall under the parenting plan, the reduction of alimony, or the attorney's fees?
And also look out for our son's emotional distress that he has been causing him by calling me names and not speaking to me and giving me the silent treatment when I'm trying.
How does the son even know he doesn't speak to you unless you're the one telling him that, ma'am? How is that coming into the son's sphere? And how is that causing him emotional distress? What does he need to speak to you about? Because he already said earlier, he's read all the tablet messages and none of them have anything to do with the son or that require a response having to do with the son. So, self-serving hearsay. Objection! But Josh Martell is smart, Brian's attorney. He's gonna let her dig her own grave. He's not objecting.
And to speak to him solely in regards to my son. I'm doing everything that I possibly can for my son. I've been avidly striving to and will continue my pursuit to be even more meaningful to my son in my continued hard-fought efforts to see him in person while temporarily located at DOC and in the meantime of my appeal and my release and all other positive aspects that I have with my son on the horizon.
Said the woman who, I gotta get it one more. I need something on my legs, sorry. Says the woman serving life without parole. Temporary, release, like all of these frou-frou words, right? We're talking about right now, ma'am. Right now. Until further notice, right? So just like when you got incarcerated and it became apparent you weren't coming out, Brian filed a motion because there was a significant change. Once your quote unquote, I can't even say it with a straight face. Once your release happens, Sarah Catherine Paulson, then you file something. But right now, Brian is asking for sole parental responsibility. He doesn't want to confer with you. You are not good at decision making.
Encouraged him, acknowledged him, understood him, listened to him, believed in him, and I make him stronger and more beautiful. Foremost and above all, meaningful means love, which the respondent ceaselessly and immeasurably will always have a wholeheartedly provide for her son, which is priceless, and no circumstance or agreement or modification in any lifetime can change or end. I'm hoping that the court can see my ceaseless attempt and whatever it is that I can do in order to stay in my son's life for longer than 30 minutes per week, please. I have a lot to offer and I can help him grow in multiple ways. And I am his mother, and I wish that I had the guardian ad litem or my son to be included in this, which, if I can also include, please, into evidence.
So there she is, beating a dead horse. I wish I had the guardian ad litem. This is not a wish list, ma'am. You don't have the guardian ad litem. This is the final hearing to discuss the parenting plan, the reduction or elimination of alimony, attorney's fees for you dragging this out. So you are wasting everyone's time wishing. Get a magic lamp, ma'am. But here now, we're not here for wishes.
It's the notice of filing the respondent's answer, the supplemental petition for modification of final judgment, which is number 7, please.
Hey, give us just a minute. You said number 17?
7.
Seven.
Please.
Yes, Your Honor.
Give us just a minute. We pulled the wrong one. All right. So what I have before me is it looks like petitioner filed a handwritten document on it's dated May 1st of 2022, but it looks like it was filed with the court on May 16th. And there was a notice of filing by Attorney Martell. Looks like he may have received a copy of it and he filed it with the court. Is that?
Let me just pull it up, Your Honor. I'm sorry.
It's okay. But I am seeing them both in the court file on May 16th of
Is it an answer to our?
Yes, and it looks like you may have filed a notice of filing just to make sure it got into the
Yeah,
court.
I no objection.
All right. So I'm going to receive what is presented as Respondent's Composite Exhibit 7, which is that notice of filing by Attorney Martell, as well as the actual handwritten answer. I'm going to receive that into evidence as Respondent's Exhibit number 5. All right, Ms. Boone, you may continue.
This was just me trying to be transparent with the petitioner's counsel and describing to them my need and want to be in my son's life back in 2022. Explaining my dedication and my decisions and ideas and opinions, they matter. one exterior enforcement incident does not define me as a person or my entire existence. And I'm trying to be my son's best advocate for myself. And 2 parents are involved. Just because I'm not there under the same roof to make the same decision, or at least I would like to be conferred with and included on so I know what's going on in the son's life. This is just me trying to know what is going on and to let them know what I'm striving for, that there comes to some type of cooperation or collaboration. This was just me emphasizing to them that I very much would still like to be in my son's life. That is my letter originally in answer to their modification of this final judgment, which we are in the process.
So I pulled it up really fast. I'm not going to put it on the screen, but it's 8 pages of a rant, really, that she received the... She received a summons for 2222 stating a lawsuit has been filed against her in the aforementioned matter. As instructed, this letter will serve as my personal individual written response to the supplemental petition, joint stipulation, and notice of appearance. I'm in the process of trying to obtain representation, but it goes on and on. Her parents are dead, her grandparents are dead. My decisions, ideas, opinions, feedback, rules matter. The fact that she thinks she can have rules for her son from incarceration is crazy. To be excluded in any way just because of my current temporary circumstances and location is wrong, unfair, and unacceptable. It makes absolutely no difference where I am. Jail, space, Australia. I am not and will never be useless, especially to our son. So it's a lot of that. How will this sole, S-O-L-E, great responsibility, should it be awarded, affect the former husband's mental ability going forward, as all instances, scenarios, and situations are not the same? That is why there is 2 parents. I believe it should be. That's why there are 2 parents, straight A student, both to broaden all horizons, outlooks, and futures for their children, and in which I am so desperately fighting now to continue to do for mine, and all _ for the right reasons. Yeah, I am no longer going to willingly make it easy for former husband to advantageously rob me of my last and only minute life resources out of bitterness, greed, and spiteful opportunity at my weakest, broken, most vulnerable moment. He is attempting to take full advantage of such with this unwarranted, vicious attack, thinking, hoping, and assuming I will wave a white flag, which I do not own. Especially when it comes to my son. You get the gist. It's in my family letters if you really want to hear it all, but just as you know, a flavor of what she's now entering into evidence, even though it's already in the court record.
The debating. For also the parenting plan, which is still active, the original from 2018, I believe, I wanted to bring to the court's attention that it's been violated by the petitioner. Again, from previously, now I believe it's a time where it says the parenting plan may be modified or verified on a temporary basis when both parents agree in writing.
All right, Ms. Boone, Ms. Boone, you have to agree that there's a lot that's not being followed with regard to that parenting plan, which includes even the time sharing that you're not able to do at this time.
Right.
You would agree with that, correct?
I understand that, but that is my only stipulation. That's my only part
Okay.
that
All right,
I'm
you would
unable to
also
apply-
agree that that parenting plan was entered into back in 2018 prior to there being any criminal charges in your incarceration. Do you agree with that?
I do, Your Honor. But it
Okay,
was
and you
still
have
in
to
effect.
also agree that when the parenting plan was entered into, if I remember correctly, you all agreed to the parenting plan as part of your mediated settlement agreement back in 2018. And at that time, neither one of you were contemplating any type of criminal charges or incarceration. Is that correct?
Yes, Your Honor.
Okay. All right, you may continue.
Read the room, Sarah. Read the room.
So I would like to bring in the part of the divorce certificate, which include each parent and everything they're supposed to abide by regarding being appropriate to the other parent, regardless of incarceration or not. That's what I was trying to say. I've been excluded this entire time, and everyone has blamed my incarceration on it, which it shouldn't be like that because I'm still.
She's just whining, right? Like, put it on paper, ma'am. What is it that you want? Specifically. You're just whining right now. Oh, he hasn't included me here. Included you in what? He is fighting for sole responsibility. So if that's granted, your inclusion is out as far as like decision making, right? So you haven't put forth any argument as to why you should be included in a decision, that you have good decision making ability. Even what you're doing right now in front of the judge shows you struggle with making appropriate decisions. She just explained to you, like, knock it off. I don't want to hear about Brian's violation of the plan when you're the one who initiated the violation by having now a criminal history, right? Nobody knew you were going to have that in 2018. So you can't then in 2025 hold him to a standard for your incarceration when it wasn't anticipated. And I think it's important because the judge noted that they mediated, right? So they didn't have to go, like, they didn't have to have a trial. They agreed amicably, whatever that looked like for Sarah and Brian in 2018. And now it's like she's making it a knockdown drag out with no clear point on what her end goal is. Well, she wants her full alimony, even though she can't justify it. She's making up numbers. And I don't know, do you guys think she really doesn't know, or she didn't know what incur meant? Is she like punking them? It just is. Let's get back to it. I could go on.
The mother of my son, regardless of where I am. And what petitioner has been saying and doing and not doing are unacceptable and to a certain extent unlawful, especially with the active parenting plan. It shouldn't be done anyway, with trying to hinder my relationship with my son. There's no reason for him to do that. And again, in conclusion, the continuation of his responses, I don't care. That's what I've gotten since I've been here. So do I bring case law up right now, or is that something I could?
All right, if you'd like to bring up case law, you can.
And you'll see, she obviously hasn't read any of the cases that she's going to cite. Some of them are not applicable. One of them is about her appeal, which I think got mixed up. Oh, I just put out a video while I was in between this. Her appellate attorney number 3 withdrew, but see that video over there. But she hasn't read it. It doesn't apply. It's rough. It's rough. Remember she harassed her brother, Phil, for that family law book? Apparently she didn't crack it open. I don't know what she's using it for. A doorstop?
Okay. So, for, I'm looking, excuse me, thank you for your patience. In regards to children and the parenting plan, Hunter versus Hunter, the court ruled that incarceration in and of itself is insufficient to terminate or deny custodial rights unless continued contact is shown harmful or detrimental to the child.
All right, give me the case name again.
Hunter v. Hunter,
All right, do you have a case citation?
yes, Your
The
Honor,
number, okay, give that to me.
540 S as in Sam, O, 2, D as in dog, 235, in parentheses, SLA, 3, D as in dog, DTA, 1989, in parentheses.
189?
Yes, 1989.
So
All right, you may
Third
continue.
District Court of Appeals.
Thank you, Your Honor. Also for that case law, the court has discretion to restrict visitation only to protect the child. The petitioner penalizes the respondent for her incarceration. Also, it reinforces that inability to communicate, not incarceration, is the key benchmark for limiting shared parenting. I have multiple ways of trying to communicate with my son. And I've been trying every single one and trying to share parenting as best as I possibly can while located here. And Speck versus Speck.
Okay, before she goes there, I've pulled up Hunter v. Hunter, and the key takeaway here is a party seeking modification of a child custody arrangement has the burden of proving, one, that there has been a substantial change in circumstances since the dissolution of the marriage. So in this case, it's her incarceration. That is a substantial change. And two, that a change of custody would be in the best interest of the children. Which, it's obvious, she can't have custody. She's in prison for life. So, I don't know how this helps her. Which is why I say I don't think she read this. The record before us demonstrates questionable behavior by the father towards the children and justifies the trial court's exercise of discretion in finding that a material change in circumstances in the best interest of the children require a temporary suspension of visitation. So that's time sharing. She technically is not going to have visitation because Brian will always be present. So they took away his visitation in this instance, and they remanded it back because they said the court is uncertain as to when he may petition the court to reestablish visitation. Won't apply to Sarah because she's serving life. And then he also wanted additional reductions in child support, retroactive to terminating his obligation to pay medical expenses. So nothing, and she doesn't call it out. Like, what applies to her case? Do you know what I mean? Like, what applies to the instant case? I'll wait.
I'm sorry, were you done or are you looking for your next topic?
Forgive me. I'm reading another case law to you.
All right, I have the Hunter case. I've gotten that. Do you have another case?
Yes, I do, Your Honor.
All right.
Please.
All right, give me just 1 minute.
Thank you for your patience.
All right, your next case?
Haven't been provided to the
Ogilvy,
petitioner.
O-G-I-L-V as in Victor, I-E.
All right, just give me the citation for now.
Forgive me. 2007 SL 2D DTA. Ogilvy versus Ogilvy.
All right, you may have to give me the spelling of the name again. Go ahead. OG.
ILVIE.
V as in Victor.
Yes, Your Honor. This holds
Right.
that.
Jennifer, hold on. Jennifer Ogilvy versus Dale Dean Ogilvy.
I don't have their first names, Your Honor. I just have Ogilvy versus Ogilvy.
All right, well, the case citation you gave me is not a formal case citation, so I have to figure out if I have the right case here.
If I
All
may.
right, go ahead and tell me your position on what you believe the case states.
It holds that parental alienation tactics, like disparaging the other parent or withholding visits, constitute interference and harm for the child. I have limited resources at the law library, so forgive me.
No, you're fine. I just need to make sure that I have the right case and I believe I do.
And then I have another one after that that has the same type
All right.
of.
Give me just a minute. All right, counsel, for the record, the court has found the Ogilvy case that I believe she is referring to, which is 954 Southern 2nd 698.
Yeah, I got it here too.
Which is a first DCA opinion in 2007.
So it's an opinion, it's not case law, but this is what I am looking at. The trial court did find that Mr. and Mrs. Ogilvy were unable to communicate with one another, but the inability of parents to communicate does not amount to a substantial change of circumstances that would justify a custody modification. See McKinnon v. Stats, Florida 1st District Court of Appeals, 2005. First District Court. I see also Cooper. The parties' failure to communicate with each other without some other material unanticipated change since the final judgment is not a proper legal ground for modifying custody. So these folks were in New York. They moved to Florida. And the father filed for a substantial change in circumstances, which Brian did here because she's incarcerated. But he filed for a substantial change in circumstances because they were having issues communicating. It further goes on to state, no evidence was submitted proving that parental alienation had occurred, nor did the trial court make any such finding. So we're in the same situation. She hasn't submitted any evidence for parental alienation, and I don't see Judge Jackson making any finding without evidence of it, right? I mean, Sarah alienated herself by murdering her boyfriend. Evidence also showed, of course, that parents and children had all relocated since entry of the divorce decree in New York. So, because Mr. Ogilvy failed to prove a change in circumstances sufficiently substantial and material to warrant modification of the custody decree, no further inquiry, so do not pass go, we didn't get past that. No further inquiry into the desirous effect of having Mr. Ogilvy involved in the minor children's lives, the parenting skills Mr. Ogilvy possesses, or whether the children were better off having both parents share in the major decision-making was justified. This does not help her. Absent proof of a substantial change of circumstances, we need not go any further. Sotomayor opined on that. So, yeah, this doesn't help her because they didn't even consider like all the stuff she's saying. If the child is better off with both parents and all that stuff that they didn't consider it because they couldn't get past substantial change in circumstances.
All right, your next case.
Logria, it's Logreira. versus Lobria. I don't know if I'm saying that name right. Sorry.
All right, is that 322 Southern 3rd 155? Do you have that?
All I have, Your Honor, is 2021 3rd DCA.
All right, for council, I have that as 322 Southern 3rd 155, Florida 3rd DCA, June 2nd of 2021.
Got it. Thank you.
I'm sorry. I'm sorry.
No, you're doing fine. We just have to locate it based on what you're saying, and I just want to make sure that I have the correct case, okay?
Thank you.
So give me just a minute. I believe I found it, and I just need to make sure that I give counsel the citation that I'm looking at. So that's why it's taken a little bit of time, just so that he's on the same page, that he's looking at the same thing the court is looking at.
Yes, Your Honor, thank you.
All right, and why do you want the court to consider this LaGuerra case?
Any restrictions must be court ordered based on evidence and accompanied by a fair hearing. Unilateral actions are ineffective and wrongful. It also emphasizes the need for due process before suspending parenting time. I have 2 more after that, and I'm complete with it.
So I'm looking at that one and it doesn't apply. This is the hearing for the modification. So I don't know why that's not clicking. And he didn't change anything. Brian did not. Sarah did. Sarah cannot participate in the time sharing because she's incarcerated, right? And then there's something in here about them attending Family Bridges, a program purporting to remedy the effects of parental alienation syndrome. So we need our therapist. We need Dr. Berry to weigh in on this syndrome. But I don't think her son has been assessed in order to determine he had this parental alienation syndrome. Here they're saying he specifically posited the children displayed unwarranted hostility as the result of indoctrination by the former wife and sought to enroll them in a therapeutic program. So she hasn't really shown any signs of Brian indoctrinating the child. There was a 9-day trial. The parenting plan was modified. The children were ordered into Family Bridges, a family reunification program. In this citation, they don't delve into the merits of that decision. So as relevant to these proceedings, the order endowed the former husband with sole decision-making authority over the children, as well as the capacity to approve all medical and therapeutic interventions, the right to conceal the location of the children, including the place of their educational institutions, and unilateral authority to travel or authorize the same on behalf of the children. Order further prohibited the former wife, from any contact with the children for an indeterminate duration, specifying that such prohibition would last for a minimum of 90 days. So it sounds like following the completion of the therapy, they're trying to break the cycle of what's been deemed alienation. But what does she want from this? Like, she wants the child to not have contact with the father for 90 days to break, you know what I mean? Like, she can't take him for 90 days. Hello. So, again, not clear on how she wants to apply this to her specific situation. My bangs are doing their own thing.
All right, give me just a minute. All right, the next case you have?
Thank you. Perez, Perez versus Perez. And I have a citing.
Okay, give me the citation.
769 SO2D 389 parentheses SLA 3D DCA 2000 in parentheses.
All right, that was 760.
No, 769.
760.
Did you
For
need the
counsel,
summary
the court,
part?
hold on a minute, ma'am, hold on. For counsel, the court has found the Deborah Perez versus Jorge M. Perez case at 769 Southern 2nd, 389, Florida 3rd DCA, 1999.
I found it.
Hold on 1 minute, ma'am. All right, why do you want the court to consider the Perez case?
Because this underscores that restrictions on parenting time must serve the child's best interest, not a parent's convenience, retaliation, or preference. Also, courts require proper legal process and evidence, not unilateral action to alter the parenting plan's time sharing term, regardless of where the parents are located.
So this case involves a guardian ad litem. It is not a unilateral decision that Brian made about shared time. Again, Sarah got arrested for murder. Not sure how this applies. I think they did. I don't even, like, her helpers may have done more than Chat GPT or whatever. There's some AI involved, or they're just looking, they're grabbing words, but this does not apply. He didn't make a unilateral decision about time sharing. She got arrested. So she therefore could not maintain the time sharing that was in the plan that was agreed to. Am I crazy, guys? Does that not make sense? Like, I feel like, let me know. Oh my God, brain cells are popping. I feel them right now.
All right, hold on just 1 minute. All right, you may continue.
Yes, please. If I could please add one more. I have two more and then I'm complete.
All right, go ahead.
Thank you. It's just stated as in regard to adoption of children by LAS, and the citation is 650, capital A as in apple, 2D, 214, in parentheses, 1994.
All right, that was 650A2D202.
214.
Counsel, have you had a
I couldn't figure find it.
we cannot find that case.
Yes, please, if I could put a substitution in.
If you can do what?
May I substitute one for that? I have another one
Okay.
in place of.
Okay,
If I could just give you the citation,
yes, that's fine.
it's 996 SO2D 930 parentheses SLA 2D DCA 2008 in parentheses.
Counsel, the court has found RE versus Department of Children and Families at 996 Southern 2nd, 929, Florida 4th DCA opinion from 2008.
Got it.
All right, and why do you want the court to consider this case?
Thank you, Your Honor. The court found that incarceration alone is not grounds for termination of parental rights, and they still have the right to raise, contact, and participate in their child's life unless proven unfit on other grounds. And one more.
Before
and
you
I'm done.
continue, hold on, before you continue, I have
murder?
not heard any arguments or evidence that anybody's trying to terminate your rights. That's, my understanding, that's not what's happening here. Is that correct?
Yeah, this is not a TPR proceeding. Yeah.
Got it. All right.
Hello?
All right. You said you have another case? All right, just, oh, actually, hold on, before you go, Ms. Boone, one of the, I don't know if you heard the court wanted clarification from counsel for petitioner. Based on everything that I've read and the testimony that I've heard here today, this is not an action to terminate your parental rights. Counsel confirmed for me that that is not what petitioner is seeking in this case. Okay, now you can go ahead with your next case.
Yes, please, if I may comment on that. It is in regards to me speaking to my son one day a week for 30 minutes, and
That
that's
is
what I'm
not
trying to...
terminate. I understand that, ma'am. What I'm saying to you is the case, and the court does understand, and there is a distinction between terminating parental rights and requesting a specific parental responsibility. So, you know, this case is not about terminating your parental rights. And the court is not considering a request to terminate your parental rights. But you can continue with your next case.
Okay, I'm just trying to clarify what my parental rights are. Spec v. Spec, S-P-E-C-K. The citation is 225 SO 3D 319 parentheses FLA 3D DCA 2017.
To Brown versus State.
Spec v. Spec.
Okay, I need a citation one more time. I'm sorry.
Sure. 225 SO 3D 319 parentheses FLA 3D
All right, the court is
DCA.
not finding a Feck versus Feck case. That is a citation for Brown versus State, which is a 2017 opinion regarding waiver of appeal arguments dealing with a sentencing order.
Okay, one moment, please, if I may.
So that's
I'm
got to
looking
be
through really quick.
regarding her
Okay.
appeal and not
If I'm just trying to locate. Okay, Your Honor, forgive me, that's what I have for that one.
I'm sorry?
Okay, that's the 225, that's what I have for that, which apparently is
All right.
not right.
All right, any additional cases?
No, Your Honor,
All right,
for
all
that, no.
right. Any additional evidence you want the court to consider?
In regard to the parenting plan,
In regards to any of the issues that we're here on today that I have recited over and over, I think I might be on time number 7 now.
in regard to the alimony, I would like please to add case law, Florida statute 61.14, I believe.
All right, repeat it for me, I'm sorry.
Just one moment, I'm trying to make sure that I have everything pulled up. Okay, I'm going to start, please. Would you like to have the citation?
Yes.
39 SO 3D 453 SLA 2D DCA 2010.
All right, is that Malik versus Malik?
Grigsby versus Grigsby.
Say the citation for me once again.
39 SO 3D 453
Okay, now say the name of the case for me.
Grigsby Grigsby.
Got it.
not have to do with alimony.
All right, the court has found Grisby versus Grisby at 39 Southern 3rd, 453, which is a second DCA case from 2010 dealing with the issues on sole parental responsibility, reestablishing time sharing.
This, I believe, was in regards to alimony.
It is not regarding alimony. All right, give me just a minute. We're going to have to go off the record for just a minute. We're going to take a 3 to 5 minute break.
Okay.
My laptop, because something happened about 4 or 5 months ago, it only charges with a specific charger. And so my computer is telling me it's about to die. So my judicial assistant is running up to grab a charger that's actually going to charge my laptop so it doesn't die. Okay?
No problem.
And I do apologize for that. But
When she comes
meanwhile,
back,
I
we
am going
lose her
to
video.
make sure I save my notes so that they don't disappear. If my computer should all of a sudden go completely out. Ms. Boone?
Yes, Your Honor, I'm here.
Okay, all right. I don't know if you were able to hear me earlier. Just so you know what's happening in the courtroom, I am in a different courtroom today. And even though my laptop has been plugged in to allow me to see on a separate screen, it was not charging due to an issue with my laptop that happened about 3 or 4 months ago. So now we have a charger for my laptop. I am back up and I am ready to take your next case citation regarding alimony.
Yes, Your Honor, thank you very much. My next is Bowen, Bowen versus Bowen. And the citation 471 SO 2D 1274 SLA 1985.
All right, give me the number after the 2D.
1274
Got it.
parentheses.
Okay.
Okay.
All right, for counsel, I have the Bowen versus Bowen case, 471 Southern 2nd, 1214, Florida Supreme Court, 1985.
I've got it. Thank you.
All right, go ahead, Ms. Boone.
Arrearages and alimony are vested rights and enforceable. While the court-ordered alimony period has now ended, the expiration of that period does not erase arrears that accrued while the order was active. Florida law is clear that past due alimony becomes a vested right, and the obligor remains responsible for payment regardless of whether the alimony term has since expired.
All right, anything else?
Yes, I have.
So this involved incarcerating the father for not paying. He was held in contempt. It was criminal rather than civil. I don't know how that. I think they just incarcerated was in there, so they threw it in.
The citation is 418 SO2C 1113. It's Florida 5th DCA 1982.
And what's the case name?
Lamb versus Lamb.
It's 418
SO2D 1113.
418 Southern 2nd, 213.
2D 1113. So 1113.
Seen that one. That site.
All right, give me the full site. Start with the first numbers again.
418
418 SO2D
1113 in parentheses Florida, 5th, 5th, DCA,
The court does not
1982.
find the Lamb case at this citation, 418 Southern 2nd, or do you say 2D or 3D?
2.
All right, that is not a citation for a case named Lamb.
Lamb versus Lamb.
All right, and I need you, how many more of these you have? We were down in 15 minutes and I gotta give council an opportunity to question you and then save time for closing arguments.
I'm not sure. That's why being on the phone is very difficult. I'm sorry. I'm doing everything that I possibly can to properly represent myself.
How does being on the phone make it difficult to count how many citations you have left? You wasted all this time. You could have counted by now. Just look at the paper. 1, 2, 3. 1, 2, 5. Ma'am.
Let's see. Lamb versus Lamb is not Bowen versus Bowen. Tindall, Tindall.
All right, give me the citation.
It's not on here. Forgive me. They didn't give it to me.
All right, without a
550.
citation, the court cannot find a next case.
I'm sorry. My classifications department is speaking to me. Hold on one moment, please. I'm sorry.
Hello, excuse me. Your Honor. Hello, Your Honor.
Yes.
This is Classification Officer Santiago. I work at Lowell Correctional Institution. Due to our procedural operations over here, she's going to need to be off the phone at 4:50 in 5 minutes. And I just thought that I would come on here and let you know.
Your Honor,
And
may
then, and then
Okay.
also for future court appearances, they are requesting that communications go through the classification officer so that we can make sure that she has plenty of time to complete all of this so that we're not having to rush her off the phone.
Right. Information was sent regarding this final hearing. And my office has been in contact with the Department of Corrections for quite some time over the last couple of months trying to get this set up because we had initially requested that she be transported to Orlando for this hearing. So there has been contact. All right, but right now you are slowing us down and trying to get this finished. So give me just a minute. Hold on. Yes, counsel.
Your Honor, what I would suggest, I have no other questions for Ms. Boone. So what I would suggest is that perhaps the court allow both me and Ms. Boone to have a certain amount of days, not a super long amount of days, but a certain amount of days to provide written closing arguments to the court, and then the court can take the case under advisement and make a ruling, so we can get this done today.
All right. All right. So what the court is going to do is we're going to go ahead and finish up, I believe. Other than case law, Ms. Boone, did you have any other evidence that you wanted the court to consider?
Yes, I did. I had some other exhibits that I would like to have put into my evidence, and then I also was supposed to speak about the attorney's fees.
I've given you lots of time to speak about all the issues. The fact that you didn't take that opportunity instead of going into other issues is not what the court is going to address now. What specific exhibits do you would like to move into evidence?
Your Honor, forgive me, but I'm here on the phone
Forgive
trying to
me
do all
when
of
I
this.
ask you what other exhibits that you want to put into evidence.
My number 10, respondents' correspondence. I'm sorry, number 9, respondents. Motion for contempt.
All right, I'm not considering a motion for contempt with regard to a final hearing. Okay? Anything else?
It was my understanding it was held in continuance until this actual moment, which is why it's been waiting to be heard.
I think she's referencing, Your Honor, the motion for contempt on the non-payment of alimony, not the most recent motion for contempt.
Her understanding is incorrect. It said it could happen contemporaneous to this or after, right? There was no guarantee. There was no guarantee that it would be held, and she did not file to have the motion heard. Right?
Yeah.
So yeah, she's always a day late and a dollar short. This one.
That she filed.
Okay.
Yes,
Yeah.
this was done,
The court will
and
take judicial notice that you have filed a motion for contempt with regard to the alimony. Okay? And that
And that
is
was back in
something that that is something that I am considering because I've got to deal with what, the alimony that was not paid, okay?
yes, Your
All
Honor.
right, so with that clarification from counsel, I will take judicial notice of your, motion for contempt with regard to the alimony.
Okay. And then also, the petitioner's account statements, which is my number 15.
Counsel, this looks like Truist bank statements.
Okay. We gave it to us in discovery. No objection, Your Honor.
All right, hearing no objection, I will receive into evidence what was pre-marked as 15 as Respondent's Exhibit number 6.
Yes, Your Honor. And then number 21 through 25, respondents, correspondence to judge regarding non-payment of alimony, parental alienation, and requests for case management conferences.
All right, these are filings within the court. The court does not need to receive this as evidence.
Okay, if I may ask for judicial notice.
All right, the court will take judicial notice of documents that were filed on October 18th, 2022, January 31st, 2023,
There should be 5.
February 22nd, 2023. I do not see a filing date with regard to number 21.
It should be 2022 through 2023.
All right, for the record, counsel, Exhibit 20 is a notice of filing prepared by yourself. Looks like, again, filing some documents that you received. Oh, no, this is notice for trial for 20. All right.
I'm going through it as well.
All right, so also court's going to take judicial notice of the notice for trial filed on, August 17th.
That's not part of my evidence. You may have gone one too far.
You just told me 21 through 23. All right, so that's 20, so we don't need that one. All right.
21 is respondents. 22 is
All right,
respondents.
exhibit number 24 is not indicating that I don't see anything on it that it was filed with the court, but it is
It was probably cut off from the copies that I had to obtain.
all right, the court does not need to take judicial notice of a request for case management conference, so the court will not take judicial notice. Anything else?
It's trying to show my exclusion in the case.
So the judge says she will not take judicial notice because it's already part of the court filings. I don't know why Sarah is still like, it's trying to show she doesn't need to take judicial notice of it. It's part of the filings.
Court has ruled I am not taking judicial notice of a request for a case management conference. Anything else?
Number 27, 28, and 29.
All right, 27, it looks like it's a letter dated March 2nd of 2023 to Attorney Martell. Any objection to this?
If it's a letter to me, it's self-serving hearsay, so I would object.
All right, I'm going to sustain the objection as to exhibit number 27. I have a November 26, 2024 letter addressed to Attorney Joshua Martell as exhibit 28. Any objection?
Same objection, Your Honor.
Sustained. Number 29 appears to be handwritten letter to Brian dated May 12th of 2024, marked as exhibit number 29.
Same objection, Your Honor.
All right, sustained. All right, anything else?
Number 31, respondents.
I would have loved to have seen that letter to Brian, but I understand why the judge didn't allow it.
Witnesses, letter.
So letter to whom it may concern,
These are my character witness letters.
It's your what letter? I'm sorry.
character witness letters.
Objection hearsay.
Sustained. Next.
Number 32,
Number 32, current judgment interest rates.
those are in regards to
Oh,
alimony arrears.
If it's just reciting the statutory interest rates, no objection, Your Honor.
Have you reviewed the document?
Let me see.
You object or you don't? Deputy, you could continue this.
I haven't seen any of these exhibits, Your Honor. My apologies. No objection.
All right, hearing no objection, I'll receive into evidence what was pre-marked as 32 as respondents exhibit number 7. Anything else?
Number 35 and number 37. They're telling me I have to go.
All right, number 35, you can approach counsel.
Okay, thank you.
Looks like something dealing with the canteen.
It's the canteen items with current pricing. That's for snacks for medical reasons.
All right, hearing no objection, I'll receive into evidence what was marked as number 35 as number 8 and what was marked as number 37 as respondents number 9.
The JK communication features and current pricing.
All right, next.
The number 37, which is JK communication features.
We
and
already
current
admitted that into evidence as exhibit number 9. Next.
Okay. And you have the GCL communication?
I have no idea what that is. If you, the next piece of evidence that you want to, next exhibit that you want to admit into evidence. Anything else?
I think we're missing one because I'm going to put in the JK communication. I put in the GCL communication, but not the JK.
We have number 35 admitted into evidence as number 8, number 37 admitted into evidence as number 9. Next.
Number 36?
Would you like me to look at this, Your Honor?
You can stay up. All right, we're receiving into evidence what was pre-marked as 36 as respondents exhibit number 10, which is also
Yes, Your Honor.
a letter. Next.
That's all I have for right now, Your Honor.
So she did submit any of her exhibits to petitioner's counsel, which is crazy. That's why he has to keep running up in there. The Human Tooth edited this part, so it's shorter than it was while we were there in person. But this was painful, and even though the classification officer said it needed to be over by 4:50, we went until 5:06. And the fact that Sarah was like, I still need to argue about attorney's fees. Like, she wasted so much time rambling. It's almost as if she thought there was going to be a dialogue between herself and the judge, right? And then Josh Martell waived any further questioning of Sarah because he already knows he has it in the bag. But it was like... she wasted so much time complaining and going over like the alienation, which was not a part of parenting plan, attorney's fees, or reducing or eliminating alimony. Like, you would think you would organize it, right? If you have like 40 minutes, because the judge said we're ending at 5 no matter what, and I have to give you guys time for closing arguments. Then you would look and say, okay, I've got 10 minutes for this, 10 minutes for this, 10 minutes for that, and be mindful of that. She spent the majority of the time talking about really what she thought was going to be parental alienation. I don't know why she would fight for sole responsibility, right? Like, Brian shouldn't have to call her to consult about, like, should his filling be silver or porcelain? Like, you don't need that level. Yes, sir. You don't need that level of involvement.
Mama, no.
And throughout the entire trial.
No, Mom.
Yes.
Mama.
Yes.
Mom.
She didn't provide any case law about her alimony,
Mama.
why she felt like she still deserved it. She didn't substantiate any of that. So the judge doesn't have to, like the judge said, she's got to take judicial notice of the time between 2020, 2022, when he filed for the modification. But that's it. And it's going to be offset by the $14,000 in attorney's fees. Okay, let's go back to the video.
Honor, I'm being rushed out.
All right, I'm going to give you all until next Monday at 5. I'm going to say by 5 p.m. That includes, Ms. Boone, you need to put it in the mail by next Monday, a written closing argument on the issues we're here on today, okay? So I'm going to give you all until 1 week to provide written closing arguments No more than 5 pages.
No more than 5 pages.
That is correct.
Parenting plan, alimony, attorney's fees.
Counsel.
Can I submit real quick 2 exhibits before we end?
All right, what are they?
I just have, these are more for demonstrative purposes, but I have my proposed child support guidelines worksheet that was marked for identification purposes as petitioners B, and then my case law, which is in hard copy form marked for identification purposes as exhibit C. This is all
Or what was the child support guidelines? Was it pre-marked as?
B.
B as in boy, and then the case law as C.
C.
All right. Ms. Boone, do you have any objection to what was pre-marked as petitioner's exhibit B or C, the child support guidelines or case law?
No, if someone explains it to me though, if we have a chance to, I don't understand it.
All right, hearing no objection, I'll receive into evidence what was pre-marked as B as petitioner's number 4 and what was pre-marked as C as petitioner's number 5.
Please, if I may, before we hang up, the closing arguments are for parenting plan, alimony, attorney's fees, and...
I am not repeating myself, ma'am. You need to make a closing statement. You need to put it in the mail to me no later than next Monday, which I believe, actually, that's a holiday. So I'm going to give you all till Tuesday, which is September 2nd. I will not accept anything that is postmarked beyond September 2nd. Again, this is closing arguments on the issues we're here on in trial today, no more than 5 pages. Thank you and have a great day.
She's not new to this, but she's true to this. I was very convinced of whatever that was. I don't know if you guys could hear that. Oh, it's a Donna Adelson. Woo! The judge was over it. Over it. So they had started at 1:30 because of the technical issues. I think the minutes say 1:26, and then we went until 5:06. So the judge was so over Sarah Boone, and then at the end she had the nerve to ask again, wait, what is the closing argument? Ma'am, the things that you should have been arguing about. So Hear Me Out was explaining when we did our live together, our download, that the judge can go outside of what Brian has asked for. So that was news to me, which it makes me excited. So maybe she will give less than the 12. And I say that for the visits. I say that because Judge Jackson's mother murdered her father, right, when she was 2 or 3 years old. And then Judge Jackson went to live with her father's sister. So I don't know if she went to visit her mom or what their relationship was like, but I'm going to guess. And her mom didn't get a life sentence. But I'm going to speculate that at some point maybe she went into a prison to visit, or maybe she was sheltered from that until she was of age and knows like that's not a good place for a child to be. She can clearly see that Sarah is argumentative, like as my grandma would say, would argue with a stop sign. The stop sign says stop, stop, and she's still arguing. So yeah, okay, I'm gonna go play with the little one. We're gonna go read a book.
Yeah.
Yes, okay. So let me know what you guys think. I'm going to stitch these together and we'll do it's 9:02 right now. Hopefully we'll do a late night read through because we're going to get him in bed after his storybook, right? You going to go night-night?
Yeah.
You sleepy?
Yeah.
Okay, good. I'm glad to hear it. Yeah. She made no argument about the alimony. I'm hoping that it is offset by the lawyer's fees and the child support, because there is case law, and I wish I had asked for that. I put in a request for their discovery, but specific parts of it, but I wish I would have requested Brian's case law. There is argument that incarcerated parents are not forgiven for child support, right? So that would have started from February of 2020. We'll see, though. We'll see. I checked the docket again. Her closing argument hasn't posted. I heard, I think it's Classified True Crime. She was on with Hear Me Out. Said that she has word that it was filed. So we'll see. Was it filed on time? I don't know. Okay, we're gonna say goodbye. Let's see if my little helper, my little co-host, wants to do toodles with me.
Me?
Do you want to say toodles? We'll see them later. Let's see. Let's get ready.
Yeah.
Okay. I'll talk to you guys in the comments during the premiere or after. Shout out to the replay crew. I appreciate you. Drop some blue hearts in the chat. And I will talk to you all later. Toodles. No toodles?
Yeah.
Let's hear it.
Yeah.
See you in the